Okay, I have to ask.
Oh, yeah.
Do you believe that it's a massive cover-up?
Now, if you're not ready, then go ahead and tell me you're not ready.
I object to you getting records. You've been intrusive into people's personal lives.
In other words, the car didn't hit him, and he wasn't hit by the car.
I'm not a lawyer, but
are y'all keeping up?
I'm not a lawyer, but
The Debrief.
Hello and welcome to another episode of I'm Not a Lawyer, but
The Debrief.
My name is Melanie, aka I'm Not a Lawyer, but, and I am joined by my co-host,
Gooseberry. How y'all doing?
And we are so excited to bring you another episode of this podcast because we have a very special guest that we are so excited about. As you know, we have been covering the Karen Reed trial on this podcast, as well as all of my I'm Not a Lawyer, but platforms. But we have a real lawyer in the building today. And so we are excited to have Miss Katherine Loftus with us today. Thank you for being here. AKA Note My Objection. Okay, that is the social media handle. You can follow her everywhere, her TikToks, all the things. We love it. So thank you again for being here.
Thanks. I appreciate having me.
All right. So we have a section. We're going to start with a section of the podcast that we call Mel's Mini Bar, because I am not a lawyer, but sometimes I like to act like I want to be one. And so I look into a lot of terms and talk about what they are on this podcast. And so since we have you, we would love to have you do a little bit of the mini bar today. If you could tell us, if you could first go through the type of verdicts that can happen in a criminal trial. So like obviously guilty and not guilty, mistrial. If you could go through what those are and then what they mean. And obviously specifically with the Karen Reed trial, what a mistrial and a hung jury actually means. If you could inform us, enlighten us and the audience, that would be great.
I'd be happy to. So in a criminal trial, the only three options really are guilty, not guilty, or a hung jury. And what a hung jury is that it means that the verdict is not unanimous. So in criminal trials, you have to have a unanimous verdict. Here in Massachusetts, and we have two different courts. We have a district court and we have a superior court. It's very similar in most states. In our district court, we have 6 panel juries, and in superior court we have 12 panel juries. Regardless of whether you're in district court or superior court, you still need a unanimous verdict either way. So similar to what's happening in the Karen Reed case, the jurors, once they went back and started deliberating, as is always the case after the prosecutor and the defense closes, the judge instructs the jury, and then the jury basically goes back into a special room and they debate. They talk about the evidence. They, go back and forth about what their different interpretations are. Sometimes they take polls quickly. Sometimes they wait a little bit to go through the evidence before they do it. And, as things go, there's the back and forth. What happens when jurors can't agree is what we call a hung jury. And the process around when a hung jury becomes a mistrial is, at least, like I said, I practice in Massachusetts and I'm admitted in New Hampshire as well. So I speak only to the laws of my state, but they're generally similar throughout the states throughout the country. So what happens here, as it did in the Karen Reed case, is we went out, the jury had the case last Tuesday. They asked a question on Wednesday, and by Friday they had said, we can't come to a decision. The judge, what our case law says here is you have to kind of nudge them a little bit. You don't just immediately declare a mistrial when they can't decide. So what the judge did last week is said, go back out. They came back Monday and essentially came back again as hung. And once the judge heard, there was a note that was written that has been talked about quite a bit. and I'll tell you, I practiced with my dad, and the first thing he said was, that must have been a lawyer or somebody with some sort of legal experience who wrote the note, because it was really it was signaling to the judge, we're working really hard back here, but we can't come to a decision.
Yeah.
So the judge then, and so this would be the same in any other case. The judge usually gives the jury, go back, work a little bit harder, try a little bit this, think that. They usually give it 2 or 3 shots before they declare a mistrial.
Mm-hmm.
And the reason why they want to wait through all that is because so much comes from having to try this, like in this case or any other case again, right? If it's a 2-day trial and it's not going to be that much, it's not that big of a deal. If you get a trial like this that lasted 9 weeks, the idea of going through it all over again is not something the courts like to do.
Mm-hmm.
So they declared a mistrial in the Karen Reed case. We won't know. The Commonwealth says they're going to retry it. So I expect that will happen. We won't know when it's going to be until later this month, July 22nd. They have a status conference, at which point, there's all the different lawyers, the court schedule. There's a lot of things that go into actually planning for everybody to be once again in the same place at the same time. So that's really what a hung jury is and how it becomes formally the legal implication is the mistrial.
Yes. Thank you for that. Thank you. So exciting that we get a real lawyer to give us a mini bar.
So in every case, in every court case, when it's a jury, every case, you have to have every juror agree.
Unanimous.
That's right.
Yeah, united. No matter what.
No matter what.
No matter what.
No matter what. So it always has to be unanimous. It always has to be unanimous. And that's why, because ultimately in criminal cases, obviously civil cases are different, but in criminal cases, one of the most important protections we have in the United States in that Constitution is the defendant's constitutional right. And so the burden not only is very high to prove somebody guilty, it's the highest burden we have in the law beyond a reasonable doubt. But on top of it, you have to have all 12 jurors. So it's really, it's a pretty high burden to convict someone, to convince 12 people of beyond a reasonable doubt. And we do that because we want to make sure that the people we're convicting of crimes, hopefully, are actually guilty and not, but you have to convince all 12.
I should have given a little bit of context as well that you are a former Massachusetts assistant district attorney, and now you are a criminal defense attorney.
That's correct.
Okay, so you have been a prosecutor. You know both sides.
Yeah, right. Actually, I worked in the Suffolk County District Attorney's Office, which is here in Boston. I was going to law school and at night, and I used to be a secretary. I typed the indictments in the grand jury for about 5 years while I was going to law school, and then I became a prosecutor. And then, as most people know, it's tough to have a living, buy a house, raise children on a government salary. So, so we went to, and when you're in the DA's office, they call the defense the dark side, but it's really the right side.
Well, having that perspective, I'm so excited to just get your opinions and thoughts about so much of this because you've been on both sides. So I don't even know. I'm so excited to start. Let's start with, are you surprised that as of now, they are saying they are going to retry this case? Was that surprising to you, or were you like, yeah, that makes sense?
It wasn't surprising to me. And I can understand why it is to a lot of people from the outside looking in. But from my perspective, having spent a long time in the DA's office, the Commonwealth really thinks Karen Reed, they believe she's guilty. They believe that she was killed by John O'Keefe. And so their goal isn't to, give in to public pressure. It's not to pay attention to what, because there's a lot on the outside of this case that's affecting everyone and everything involved. They do have an uphill battle because they have some problems with, aside from everything else, there are real problems with the case. But the way I like to explain it to people is, ultimately, the prosecutor's job is to try to get justice for the victim, John O'Keefe, and the victim's family. They believe Karen Reed is guilty. And so when they look at it, they say, it's worth going through this again. It's worth all this trouble because we think she should be held responsible for what we believe she did. So I'm not surprised, given that they think she's guilty.
Yeah, got it.
Wow.
One of the things that, just from my interest in following trials and trying to understand them, is I have seen where things can happen that there can be some changes between the first trial and the second trial when there is a hung jury, including who the witnesses are, who comes to testify, including even some of the evidence. I've seen motions get filed that affect stuff that may have been presented in the first trial that maybe the judge now rules will be excluded in the second trial. Can you just talk a little bit about, number one, any of the things that can change and how, just kind of like how that happens? Can evidence be excluded? Can witnesses change, especially with the news about Michael Proctor? Is it likely that he may not testify? There was rumors this first time, so that was a bunch of questions in one, which would be an objection in an actual trial. But
I'm gonna add a question.
Go ahead.
Compound objection.
Will it be the same judge?
It probably will be. She took jurisdiction of the case last year. It doesn't have to be, but it often is, depending on who's sitting in the court and what the schedules are. But the difference, your observation is correct, because oftentimes, and I've kind of talked about this a little bit the last couple of days on my page, that it could be theoretically like an entirely different trial. We could have the Commonwealth present sort of a different type of presentation of the case. We could have the defense focus on different things. And so people watching it from one to the other go like, how is this possible that you had one theory in one way to present the case the first time, and now it's completely different? But what happens for both sides really in a mistrial is it's this rare opportunity to look at what worked, what didn't, and could we have done this a different way that would be more effective? Yeah. So there's no rules against, as long as you're not manipulating evidence or changing things, there's no real rules about how to present the case and in what manner under what theory. Now, I would be surprised if the Commonwealth still proceeded on the second-degree murder charge. So Karen Reed was charged with second-degree murder, manslaughter while driving under the influence, and then leaving the scene of personal injuries. And when the jury was charged, the manslaughter had lesser included, but ultimately there were the 3 charges. In the first trial, I didn't see any evidence of intent that you would need to prove the second degree. So I think that there's a good chance the Commonwealth only goes on the manslaughter charge. And if they do that, then they only have to prove that she was intoxicated, reckless, and hit him, which would mean you don't really have to get into a lot of the other evidence that they put in that they tried to prove her intent. The voicemail, the driving back and forth, that was how they were trying to prove the second degree. So it could be that, we have a very different case when we come to the second trial. I know there were more questions in there, but now I forget what the follow-up ones were.
Okay. One of them, it was about Michael Proctor and this news about Michael Proctor.
So Michael Proctor has been relieved of his duties from the state police. So Michael Proctor is obviously the one who was the lead investigator, all those crazy text messages that he had to read on the stand. And so he's been relieved from his duties from the state police. That doesn't mean he was fired. What has happened basically is, and as kind of a precursor for if anybody's not here in Massachusetts or, watching, we have, especially our government, our police, our teachers, our fire, we have very, very, very strong unions. And so it's really, really difficult. Really difficult to get people fired. Because unions, I'm a union girl, but they have to protect the bad to protect the good sometimes too. Yeah. And so what's happening now with Michael Proctor is he was relieved of his duties, but that doesn't mean fired. It just basically means he was transferred out of the Norfolk County District Attorney's office. He'll have a hearing on whether he can remain employed or he'll be suspended with pay or without pay pending the rest of the investigation. Okay. So the investigation might not be over for, it could be 3 months, it could be 18 months. We don't know. So unless something, it's my opinion that unless there is a conclusion from the internal affairs investigation, or there is some intervening indictment from the federal grand jury investigation, which I don't expect to happen, it'll probably be like the same thing the second time around, because he'll just testify as to, what he did, it'll really almost be that would be really the same. The only thing is the Commonwealth could choose not to call him, because lots of other police were with him. Most of the other things that he did, he had somebody else with him, so they could testify to that in his place, which would then force the defense to call him, and that would be an interesting, So there's lots of the thing that I think people, have come to realize as slowly watching cases and things like this is that there's lots of ifs in the law, and it's like this has to happen for this to happen for this to happen. So we'll see.
Got it.
That is, for him to have this evidence against him and the union is able to keep him employed is wild. Also, he should just go ahead.
I think, the interesting thing about Michael Proctor from a legal perspective is there are a lot of allegations against him, but I'm not sure how many can actually be substantiated. There's this inference that he's planting evidence. There's this inference that he's colluding, but there's not really actually any evidence of it. So I think what you're left with is the text messages, the fact that he didn't take himself off because he had a conflict of interest. So still, I'm not trying to minimize them, but just looking at it as a defense attorney, I think some of the things that we think about Michael Proctor are not necessarily provable in terms of misconduct within the state police. So I wouldn't be surprised if he kept his job. Crazy.
Well,
That sounds crazy.
No, I get it. That's good.
He should be doing the parking tickets.
Yeah.
I'm satisfied with that.
I am curious who you feel like was the strongest witness for the Commonwealth as well as the defense, and who you feel like were maybe the weakest witnesses for each of their side. Who would you call on both sides, and who would you not call again?
I would bet that I really liked Kerry Roberts, who was one of the women who Karen Reed called that morning to come in, because she didn't have anything, she was like, to me, maybe the most uninvolved out of everybody. She just got called that morning. She wasn't there the night before. She wasn't involved in anything. So I do think that her recitation of what her memory was and what Karen Reed was doing and saying, and the call, we didn't hear from the public didn't hear from the niece and nephew, but I have been told, based on what she testified to, that seemed to be more persuasive a little bit to the jury. So I think the problem with a lot of the Commonwealth witnesses is that it wasn't necessarily the substance that was bad. A lot of the Commonwealth witnesses had substantively good testimony to give, but they did not present well. So I thought like the vast majority of them didn't present as good witnesses, which, as lawyers, sometimes it's not really about what somebody's saying. It's like whether you like the witness. If the witness is likable, jurors and people watching tend to believe what they're saying a little bit more, whether that's right or wrong. But if you come off really, standoffish, even if you're telling the truth, it's not going to come off that way. So, and I think that, who else I loved for the Commonwealth was the cell phone expert. Yes. Yeah. She was so cheerful. Like she was a nice break for them. Yeah. For the defense, I thought 100% was the car accident reconstructionist, because they were so smart, so qualified. And they just, they came off as entirely credible. So absolutely, they both had ups and downs, but obviously the Commonwealth had so many more witnesses that they had more bad than good.
100%. Oh, I thought you were gonna say something.
The reconstructionist for the defense, right? Okay, we weren't talking about Paul.
No.
Okay.
We weren't.
No,
Okay.
I thought Trooper Paul, and I feel bad because it's like the pressure that comes from outside knowing, I mean, locally, this case has been crazy for the past year.
Yeah.
Like it's taken over everybody's lives. So I think a lot of the witnesses, including someone like Trooper Paul, you know, if you're kind of an anxious person anyway, and that, you know, you're in a job that you're working all by yourself. So he probably was that kind of person. I think it got to a lot of these people on the witness stand that they knew they're going to be on national TV. Everyone's going to tear them apart. But so his lack of knowledge combined with his nervousness, it was not good. It was not good.
Yeah, I felt sorry. I felt bad for him.
On that note, to the point that you're making about witnesses being on the stand and the perception that the people in public and theoretically, I guess the jury as well would have based off of how they present themselves and their testimony. I'll give my opinion, then I'll ask yours. In my opinion, that extends to the attorneys. Listen, Alan Jackson is a time, okay? His presentation, the cadence, the delivery, you're on a ride, and it's so, I feel like storytelling, right, is so important when it comes to being an attorney and an advocate. It's so important because you are talking to these 12 people and you're trying to take them on this journey of whatever you're saying happened or didn't happen. And so it's just so important. And Alan Jackson, I feel like did that really, really well of the attorneys that we saw. And the Commonwealth struggled a little bit. And I'm just curious from your perspective, having been on both sides, what your thoughts are on that. And I guess if what I'm saying, if you agree with that like storytelling and like how you present that and weave something together really is an important piece in proving your case.
It is. And you're exactly right. And I actually have been talking a lot like the past couple of weeks about literally using the word storytelling, because being a trial attorney is very different than just being an attorney, because a lot of what we do is showmanship, right? And it's about persuasion and how to get people to believe things that maybe they wouldn't, but if I'm, if I can sell it, maybe somebody will buy it. So in the context of both the defense and the prosecution, it's very clear that the defense had the upper hand in this, in the way that they told their story, the way that they questioned the witnesses, the way that they dealt with the judge, the way that they, talked to the jury, both in their opening and closing statements. And I think the problem, there are a lot of, not everybody is as, I would say, like bombastic as Alan Jackson, but you can still be a persuasive storyteller, even if you're quiet, even if you don't have to always be, the man. But the problem with Adam Lally is I think he had a very deep understanding of what the evidence in his case was, but he doesn't have that quality. You kind of need the two in order to convince the jury and the public. And I think that it also, I feel like he a little bit got the shaft because he's the only person who asked any questions of all those witnesses, whereas the defense had the opportunity to Attorney Little, Attorney Yannetti, Attorney Jackson. But I think it's very clear from how everybody reacted to the attorneys was that one side clearly had the upper hand. It'll be interesting to see. My suggestion would be that they should put somebody else on the case with them, even if it's not for all the witnesses, but just kind of, because I do think I'm of the opinion that if you had the right prosecutor, remember Alan Jackson and David Yannetti were prosecutors. So there are lots of prosecutors who can try a case like that. So if you had that on the Commonwealth side and they cleaned it up a little, I think people might have a different perspective. And not that it would necessarily convince them, but it would be more persuasive than it was.
Got it. Interesting.
So they both were prosecutors before.
Yeah, Alan Jackson prosecuted. He worked in the LA County District Attorney's Office. He prosecuted Phil Spector, the recording guy.
Yeah.
Yeah, who killed his wife, I think. And he was there for a long time. And then Dave Yannetti was in the Middlesex DA's office, and he tried really serious cases. So that's why we say all the best defense attorneys because they know both. Because we know both sides, so it's a different kind of analysis. You know.
Sure.
Yeah.
Okay, I have to ask.
Oh yeah.
Do you believe that it's a massive cover-up?
I don't.
No.
Mm-hmm.
Oh, tell us more.
You know, I am just, you know, people, I'll tell you, people are like, most people are, what? You don't believe it? But I'm somebody who, if you want me to be convinced of something, you need to really prove it to me. And I think there's a lot of problems with the case. There's a lot of inferences and speculation, but there's no actual evidence that anything else happened. I'm not convinced. Like, to me, the Commonwealth did not prove their case. So I don't know. I don't know what happened. I don't know what happened. I don't think that they proved her guilty of hitting him beyond a reasonable doubt. But I definitely, in my mind, at least with what I saw in the trial, I have ruled out the idea of this cover up. And a lot of that, the reason I come to that is because I really do not believe that you could get this many people in on it through 2 grand juries, through a federal grand jury where they're all being pressured, you know, and we have Brian Albert, who's a police officer, Brian Higgins. So it's like, okay, they can probably stand firm, but you just have like civilians, you know, stay-at-home moms, Brian Albert Jr.'s friends, people who pulled up in front of the house, you know, those kind of people, in my experience, would cave. And the fact that nobody has and that testimony has stayed the same, I think that the only way to explain the evidence against Karen Read is by presenting a third-party theory. And I'm not against the idea of a third-party theory that something else could have happened. I just don't believe it's the way. I don't believe he was beaten in the house and then dragged outside and everybody's, you know, in on it. I don't believe that. But I'm also, you know, my standards are very high. Just like I feel like the Commonwealth should prove to me that Karen Read did it. If you can't even pinpoint which person out of Brian Higgins, Colin Albert, or Brian Higgins committed the murder, I'm not accusing people of murder that there's no evidence of. So that's where I lie. And I can always be convinced if something else comes. I'm just at this point, I'm in the minority for sure.
Yeah.
I'm with you on that. On the part of, I'm so confused on how they could have gotten all these
many people
to, you know, come together and say, yeah, we're going to lie for this guy, you know, and none of them really, most of them didn't even know him. So I stand with you on that.
And if you think about, you know, it's like, we have to, like, sometimes I think because the case has been so sensationalized that people kind of forget to just like, let's bring it down. Like, let's see what we have instead of like the speculative stuff. And, you know, I mean, you're giving those people a lot of credit that at 2 o'clock in the morning, all wasted, they come up with a story that by like 6 has never changed. I mean, that's giving people a lot of credit. Well, it's not the mob, you know, where like they know what to do.
Yeah.
And like fall in line.
Yeah.
I don't know.
But I think here's what I want to say, because I appreciate differing perspectives. Like, I appreciate, especially obviously you do this, okay? And you've done it on both sides. So I appreciate hearing and understanding this ain't really jiving or adding up the way, you know, and I recognize obviously from the public perception, we can take pieces and run. And one of the things that I say all the time is that things can look very different under cross-examination. You can hear one side, you can read a document, and as soon as cross-examination happens, things can start to look differently. So I, again, always appreciate both sides. I think you're raising a good point. I mean, you can't tell more than 2 people a secret. If you do, chances are it's not a secret no more. And so I think that is a good point. But the leaf blower in the red Solo cup will forever have me questioning what the heck happened that day.
Well, you know, for me, that's really why, for, you know, I would say I've really been trying to focus like my audience on what's the legal standard, right? Because we're not trying to, I mean, I understand that the defense is like publicly is they're basically trying to prove to the public this cover up, right? But that's not what they have to do in court. They have to prove that they have to say, you cannot find her guilty beyond a reasonable doubt. So I have always thought that the cover up kind of theory and the way they presented it, it's almost a distraction because as a defense attorney looking at this case, there are so many screw ups by the police that it's like a gift. It's like being handed here's your reasonable doubt on a silver platter. And so I was very surprised that in the closing, they didn't say listen, basically you should say, even if you morally think she's guilty, there's no worlds where you can find her guilty because they didn't do A, B, C, D, E, and F. But instead of focusing on like he was killed in the house and drug out, I think it distracted some of the jurors from the idea of reasonable doubt. And that's really what the case is about. It's not about, sometimes it's sometimes it's right in front of you and you miss it,
And due to the mistrial, and after they look at this podcast, they probably will approach
it.
Yes.
Adjust the strategy.
Maybe. Well, and that's like what you were talking about in the beginning, Melanie. It's that they'll look at different things and maybe they'll still do the same, but just not as aggressively one way. And, they got to figure out what worked and what didn't.
Yeah. One of the things that I think I may have looked at a video, like I said, you've been everywhere for all the things. So I can't remember what it was, but you were talking about the defense having this third party and basically putting across what they believe happened and how that could be dangerous because it locks in for the jurors that they either believe it happened this way or believe it happened this way instead of having to believe it happened this way or it didn't happen that way and I have reasonable doubt and therefore I say not guilty. But if you give me another option and I feel like I'm locked into that, then I'm stuck with these two. And what if I feel it's not A, B, I feel like it's C, but I don't feel like I have C.
Well, and I think that's because the question that the jury came back with was about the CERT team evidence, which is that evidence found on the scene. So I'm like, okay, so they're not thinking about anything else. They're thinking about, did the car hit him or not? Like that's, we're coming in down to the crux of the question, right? And with the defense saying, no way, there was no accident, there was no hit, there was no glass thrown at the tail light, that these are all planted. If you don't, as a juror, if you don't believe they're planted, then you come back to, well, how did they get there?
Got it.
Right. And so then in your mind, you go, well, something had to hit something, because I don't believe that the state police trooper, as messed up in a POS as he is, I don't believe he was smashing taillights and planting the evidence. So if the evidence was there, how did it get there? And so you skip the reasonable doubt. You know what I mean? Because the defense has told you it's all fake evidence, basically. It's almost like they burden shift a little bit because then the jurors feel like, well, that's wrong. I ruled that out and you only left me with this. So that's why I was surprised when he closed, the day of closing. I was very surprised that was the tactic that they took.
You just talked a little bit about burden shift, which I think is so important just to like touch on about that. It is the burden of proof lies with the prosecutors. They have to prove that this happened, and the defense, they don't have this burden of proof in that way. They don't have to prove the way that it happened. They have to give you doubt in the Commonwealth story. And so to the point that you're making, when they start presenting a story, that burden becomes shifted. And now the jurors are like, okay, well, prove to me what you're saying happened, instead of just give me a little glimpse that it maybe didn't happen the way they said. So anyway.
Right. Yeah. And that's when David Yannetti said, and I was surprised by that when he said in their opening statement, she was framed. And I was like, whoa, that's a big allegation. If you tell me someone's framed, I want proof that they're framed. Yeah. And so when you don't fulfill that promise, and I know other people disagree with me, obviously they think he did fulfill that promise, but obviously that was not persuasive, at least to some of the jury. So I say focus on the reasonable doubt, focus on the reasonable doubt, focus on the reasonable doubt.
I do think that the officers were lying now. Now, if they were framing somebody, it's so crazy. Like you said,
and when do you mean specific? Which ones do you mean? Like specific officers or?
So when officer, I think it was Lank, he was saying he didn't know the Alberts, or we're acquaintances or whatever he said. But in the past, he literally saved Chris Albert several times. So he knows these guys, and they pointed that out. So you're obviously lying. We caught you. So why are you lying? So that tips me over to like, oh, you are in on this,
So I think from the way I look at it is that multiple things can be true. What happens with them, from my experience, is that it's not like an overt, oh, I'm not going to look because you're a police. It's just like, oh, he's a cop. No, her taillight was smashed. Somebody heard her say, I hit him. Like, so why would we, like, it's almost like an unconscious bias to each other that they don't go any further when there's fellow police involved. So that's why I think the police investigation, the fact that they collected things in red solo cups, the fact that they didn't put a police officer on the scene, the fact that they were, using the Canton Police Department when they were not supposed to be, and, all those things go to this sort of like brotherhood and thin blue line. And so I think what happens is not necessarily that they are overtly participating in covering something up, but they just don't. It's like, oh, we solved it. She was, it was her, and we're not even going to look any further. And why would we look? Because it's, he's good. He's a Boston cop. It's just this like, it's sort of like this underlying sense of I feel like it's almost like a family would protect each other, like unconsciously. And so they don't look any further. And that's a problem. I mean, that's the problem. That is the problem. Sure. But don't get me wrong. But I think there can be like laziness and ego and arrogance on behalf of the police, separate from like participating in framing someone.
I have a question on that note. Do you see there being a difference between the officers who did the investigation, as far as when you're talking about like cover up and being involved in even this brotherhood, versus the people who were at that house? And so more specifically, Brian Albert, Brian Higgins getting rid of phones. Brian Albert, Brian Higgins, butt dialing multiple times. The sister, Jen McKay. Like, do you, and I'm generally asking, do you see those differently, as in like, oh, unconsciously doing this thing? Or do you think there could be some overtness in that?
Oh, I mean, I think they got rid of the phones on purpose, 100%. I just don't think that it means it's because there was evidence of a murder and cover up and all that on their phones. I think the context is also important in that here locally, as the case was going on, prior to these motions being filed, I mean, we were already in like full-blown harassment mode of all these people in the house.
Sure.
And it was very clear that, so the defense had just begun naming all of these people. And I mean, everything was televised here, and they're on TV accusing these people of murder. Colin Albert, Brian Higgins, like very big, serious accusations. They all have attorneys, things like that. What I said at the time when this kind of was all coming up is, if somebody's accusing me of murder, right? They're going to find something on their phone, on my phone, if I give it to them, that's going to help them. They're looking for something. They're finding something. So, if a client comes to you and says, hey, I heard they're going to serve this order on me, and my question is, did you get served with it yet? No. And he's like, you have no under legal obligation. I think that like I said, there's so many. I would bet, like my prediction at the time was that maybe there's similar stuff to what they found on Michael Proctor's phone, stuff that's not becoming of police officers, stuff that they shouldn't be talking about behind the scenes, because whether people like that reality or not, like that's a reality. Like cops are talking to each other like that. They're probably talking about defendants like that. So if you're taking a sergeant in a police department, a Boston Police Department, or an ATS phone, I would probably bet money that you're going to find something that does not look good for the police.
Problematic.
So do I think they were hiding stuff and they destroyed them? Yes, 100%. Do I think that automatically to me equals because it was a murder? No. The interesting thing about it is that the order was eventually denied. So they never would have had to turn their phones over anyway.
Nah, they were probably like, man, lost all those pictures.
If they had just held on to them, they wouldn't have been able to make that argument. But see, now they can make the argument, and it doesn't even matter what the truth is because they have the ability to make the argument, right?
Can you explain why the jurors couldn't know about the federal investigation? I assume because it's not closed yet. And if I was a juror and heard that they were being investigated by the feds, I would probably say, tell me more. Maybe they're guilty. But you're the expert. You tell us.
No, you're right. Your assumption is right, is that because there's no finding or no conclusion, it's not, if one of them had been indicted by the feds, 100% we could inquire about it. If there was a conclusion from the federal investigation, we could likely, at least in part, inquire somewhat about it. But anytime there's an open investigation, even right now, we don't know if it's open. We don't know if it's closed. We don't know if anything's coming. So the court looks at it as far too prejudicial to really all the parties. And that we weigh evidence probative versus prejudicial. Is the probative value, is it more helpful than it is prejudicial? And because there's so much, imagine if they were like, oh, and the police are under investigation by the feds. What does that do to the jury? It just puts your mind in a spin, and so it would be too prejudicial, and so that's why it wasn't allowed in any of the questioning.
Got it. And then the other question I had was, there was a lot of back and forth about the verdict sheet, and at first the judge basically said it's fine, and then she later came back and adjusted it, and then Alan Jackson asked for even more changes, and eventually it happened. But can you kind of take us through what exactly that was about?
Yeah. So they didn't like the jury sheet. Now it was the standard jury form. That's the way all of our, jury for verdict forms basically. So if there was a piece of paper, the top was second degree murder and a guilty next to it or not guilty. And then underneath was, so there were 3 different charges. So you get 3 different verdict sheets. So you get one for second degree, you get one for leaving the scene. And then the one that was at issue was the manslaughter while driving under the influence. Oh,
hold on. Okay, you're back. Yeah. Okay. You said you got one for second degree and then you froze.
And then there's another one for leaving the scene. But the one that was at issue was the manslaughter while driving under the influence. And the reason that was at issue was because they gave lesser included offenses. So what that means is in order to prove vehicular manslaughter while driving under the influence, they need both the elements for OUI as well as manslaughter. And then underneath that, less elements need to be proven for OUI homicide and just involuntary manslaughter. The issue was that Attorney Jackson wanted guilty and not guilty next to all of them, the way we generally do it. And I thought actually it was a very reasonable request because, just because something hasn't been addressed before in court and just because that's the standard form doesn't mean it can't be, made better. And so I think it was a fair question to say, hey, can you just put a not guilty line next to the guilty? And, I generally I don't think it would have been a problem because what you would do is if they came back guilty, you would poll the jury to make sure that they all actually voted guilty because, realistically, they're not checking the guilty box just because they don't have a not guilty box. You know what I mean? But I do think that it was right that Jackson addressed it, that the judge eventually changed it. And then, they still couldn't agree. So,
yeah.
So let's say there is a mistrial and they find Karen not guilty. What then? Is there any more suspects, or it's just like the OJ case where it just goes unsolved?
So the way that I generally put it is the Commonwealth, they charge who they think is guilty. And we don't want a system where we charge someone, they're found not guilty, and then we're like, let's find another one, you know? So it actually, the fact that they don't look anymore most of the time is what we want, because from their perspective, we know, the Commonwealth would say, we know who did it. It's Karen Reed. We didn't prove it, but we don't think anybody else is responsible. So that's why, this will be if she's found not guilty the second time, that's the end of it. Outside of, I expect there's going to be some civil litigation, probably back and forth, but that'll be the end of the criminal case.
And you think with the civil litigation, it will be O'Keefe's side suing Karen?
Wrongful death.
I do. I think they'll probably, there's a good chance they sue her for wrongful death. Kind of like the OJ case.
Yep.
Basically, is go after her in civil court, because in civil court, it's preponderance of the evidence. So it's only 51% to 49%. You only have to prove it's more likely than not that she hit him. Yeah.
Oh, okay. So no jury.
That's why it's easier to prevail in civil court than it is in criminal.
Yeah. We had a question from our Patreon, and this will be my last one unless you have another one.
Well, I do have. Do we have? I haven't heard anything, but do we know if O'Keefe's family believes she's done it or not? Has anybody spoken out and chose a side? Or
they're not public about it, but it's my understanding they believe she did it. And I think that's, then they really, it's really, and I do feel like it needs to be said that they get a lot of pushback on them for believing Karen's guilty. And I think it's wrong, because they've lost 2 kids at this point, and everybody's entitled to believe what they believe. And but I think the reason they haven't spoken out publicly about it is because they're afraid of the backlash, most likely.
Yeah, that'll be a lot.
Okay, so then the other question from the Patreon was regarding what the jurors get when it's time to deliberate. Do they get all of the evidence presented, which is always interesting, because as things are being admitted, sometimes they'll say this is just a demonstrative, and so they don't get like demonstratives, right? They get like proper evidence that has been admitted.
Right. Only the things that have been, so sometimes things we call them here as marks for identification purposes. If that doesn't then get admitted, then the jury doesn't see it. So only the things that are marked, admitted into evidence, and have an exhibit number on it. So they'll get, they get all the physical evidence, any, documentary stuff. They don't get transcripts or anything like that. They only rely on
like the court reporters, none of that. That's why they take notes.
Yep. And that's why it's good, you get a little nervous as a lawyer, because sometimes you'll be trying a case and you'll be like, you're not taking any notes, buddy. You're not going to remember all this stuff.
What I said.
Yeah. And that goes to, that goes a lot to what we talked about in this case is people's memory. That's why my advice to everybody is always, if something happens, you write it down. So you have, it's most reliable when it's contemporaneous. And that's why you got to have jurors who are good note takers to really, have faith in it.
Yeah.
The judge kept saying that too. Y'all make sure y'all take notes. She said, all right, have your notes back. Yep.
Yeah.
Interesting.
Yeah.
Well, thank you so much. This has been great. Thank you for joining us, giving us your insights. It's been lovely to have you.
I appreciate it. I really do.
One more question.
Sure.
Do you know the Alberts in any type of way?
I don't.
You don't?
It's funny. I get called. They say, "Oh, you must be a McAlbert." If I say anything that that side doesn't like, but I'm a Southie kid. I don't know any of them.
Yeah, one of our other guests was
we had a retired state trooper on, and he had a connection to
Berkowitz,
Chief Berkowitz.
Oh,
he was his drill sergeant.
He said, interesting.
Yeah. Listen, I know a lot of the attorneys. So I know, some of the players, I know that, not the judge, but I practice in this area. So I know those kinds of players, but not like the witnesses or anything like that.
Yeah. I love it.
Cool.
Can you just give us one more time how people can find you on all the platforms?
Yep, I'm on Note My Objection. You see it back here. This way. I post mainly on TikTok, but I'm actually I'm going on a little bit of a tour talking about the Karen Reed stuff and starting my podcast. So, come and join. We like people who engage in debate. They respect other opinions, so lots of this. This is nice.
I love it. Well, thank you so much. Have a fabulous day.
Thanks, and happy 4th.
Thank you.
Thank
you
you.
too.
All right.
Okay, so thank you to Katherine Loftus, aka Note My Objection, for joining us on this episode of I'm Not a Lawyer, But. And thank you to the audience for watching and listening and having an open mind and being open to perspectives that are different from yours. One of the things I said about the trial was when the phone expert came on, I said I liked her. I didn't believe her, but I liked her.
Yep.
And I hope that is something that the audience listening can appreciate as well. Even if you may not like any guest that we have on this podcast, I hope that you can be respectful and appreciate their perspective and still say, I agree or I disagree. So anyway, thank you again to Katherine Loftus. I appreciated having her here.
I did too.
And engaging in this conversation about this case. So with that said, until next time, you can follow me, I'm Not a Lawyer, But on all of the platforms, all of the things. Make sure you like and subscribe, share, amen, all of the things on this channel and all of the platforms.
And you can find me on IG at GOOLZBY.
Until next time.